So,
Yes.
first thing first, you understand that you are no longer an
No.
So,
We remain as consultants to him and as his brothers and braves in council.
okay, based on today's proceedings, what did you observe and what to do with it?
Well, my observation is that let's keep in mind that 14th October this year, maybe 10 years that this case has been pending, that the matter has become too complicated for the judiciary to handle underscores our core point that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to be limited wiggle room of a court of law of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention for this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Let's talk about
The procedure today?
the proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that. By Sama Square, Opera will proceed.
Okay, actually, it's good for us to put the record straight. Nnamdi Kanu is not saying that he will not enter the fence. Nnamdi Kanu said, under what law are you charging me? Going by the Constitution, there is no charge against him. That tell me the law. That is, the court should tell me the law upon which he's being tried. Now, my lord is on so saying that whatever thing that you have to say should be ruled at the final written address, and it should be on a conviction to know whether they're supposed to be convicted. I'm not saying that Kanu said no. There are thresholds, there are hurdles upon which you need to cross for you to reach that particular issue. And one fundamental issue there is that my lord said we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion of Nnamdi Kanu file, Nnamdi Kanu said Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Nnamdi Kanu made reference of the motion in the court file. Yes. And under the Evidence Act, Nnamdi Kanu is saying that under the law, court is is obliged, is under obligation to take judicial notice of every document in your file.
Yes.
So asking him now to go and enter into a defense and start giving evidence on that is a waste of time.
Yes.
That court is on its own supposed to take so much to raise this issue.
Yeah.
Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And my Nnamdi Kanu filed a motion, and I think that motion, Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So I'm into defense. So my law, Nnamdi Kanu defend his position on that. So my law said that he has run to tomorrow for him to get that defense. Just like we said, you know, we are no longer into the matter, but we are still consulting us. I am saying so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice just to get the record straight, so that people will not say that Nnamdi Kanu refuses to that defense. No, there is no such issue. Nnamdi Kanu said, address me on this issue. Okay, that's
the honorable member here would like to say.
My name is Right Honorable Obi Akoche. Represent the great people of Iguana, Umuahia North and Umuahia South for the constituency of Abia State. I represent Mazi. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Nnamdi Kanu to put up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended, for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know, is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
The law that I have contravened. Yes. You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they missed chapter 45 of the criminal code. They didn't make it. But honorable, people make that law. It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existent. Thank you. In today's proceedings, Nnamdi Kanu continues to defend himself against the charges brought by the federal government of Nigeria bordering on terrorism and membership of IPOB. Today is unique because today he interrogated in court and the prosecution and charged them to prove to him or to show him what law he is alleged to have contravened. You know, this is Nigeria. We practice what we call written laws. If the laws are not made or written by the National Assembly, then they are not in existence. And if the laws have been repealed, of course, repeal it means cancel. If a law is repealed, it means that law is no longer existing. Now, if a law has been repealed, according to Nnamdi Kanu, he cannot be asked to stand trial on those laws. And he has asked them to show him the law under which he is tried. And it is for the court and the prosecution to say, you are tried under section so and so of this law. And if you do that, you will now check whether those laws are still existent in Nigeria. If they are not existent in Nigeria, then it means the young man may actually be correct to say that there is no charge against him. Of course, knowing that there is no law existing such as the ones we are furnished with. Part of the challenge we have in this court is that the Supreme Court had also ruled that there is nothing like Chapter 45 of Criminal Code. There is nothing like Chapter 45 of covering on Criminal Code. And Nnamdi Kanu is being tried under that Chapter 45 that the Supreme Court has said does not exist. So which law, which defense do you want him to put in a case where there is no written law? For one, I don't know how to even defend or interpret such. If the law is not existing, the best thing is to strike out the charge and let the young man go home. And that is why he told them, how can you detain me for over 3-4 years when the law is not existing? When the law has been repealed, when the law has been cancelled? How can you detain me for 3-4 years when there is no law like Chapter 45 of the Criminal Code? So he is challenging the judiciary, he is challenging the Nigerian authorities, he is challenging all well-meaning and all well-thinking Nigerians to find out, to ask, to raise the issue and find out whether in this country the laws have changed to such that you cannot try people when there is no law in place. Can you try people when there is no written law? If you ask me to enter a defense, is it not for me to defend a written law that I may have breached? If you say I breached Section 2 million and there is nothing like Section 2 million anywhere in this world, for goodness sake, are you not jeopardizing my right to fair hearing when you ask me to defend myself against Section 2 million when Section 2 million does not exist? That is the simple question Nnamdi Kanu posed today. And unfortunately or incidentally, the court ruled that it will not answer that question now, but will answer it at the end of trial. And Nnamdi Kanu is saying, how can you try me when there is no law? You must first of all cross the hurdle by bringing up the law that I preach. Then you cannot try me under those laws. If you cannot try me, if you want to try me under a law that does not exist, then it is a breach of my fundamental human rights. So that is as simple as Nnamdi Kanu put it today in black and white. And he relied heavily on Section 36, subsection 12 of our Constitution. Thank you.
Well, anyway, I'll just say a few words. There is this saying amongst lawyers generally that a goat was running, and when the dog saw the goat, the dog also started running. Well, the fowl observed what was going on and asked the dog, "Why are you running? It is the goat that they are chasing." The dog said to the fowl, "In this country, Nigeria, if they are chasing a goat and you are a dog, you don't run. If they catch you as a dog, before you prove that you are not a goat, you will take 10 years to 20 years." This appears to be what is happening to our brother Nnamdi Kanu. I don't speak as of counsel. I speak as of his brother, as a fellow Igbo man, and as a Nigerian, to strongly condemn what is going on. This has been going on since October 2015. We have a man on trial since October 2015. That's over 10 years ago. And out of these 10 years, you detained him for almost 6 years. And you still have him on trial. What does that tell you? It tells you the story of the dog and the goat. It's taking him 10 years to prove what, or to disprove what? Or 10 years for the judiciary of Nigeria to find him guilty of what? Guilty of self-determination? Guilty of making a broadcast from Kenya or from UK? What are we here for? What are we talking about? Why are we defeating ourselves? Why are Igbos keeping silent? I'm calling on Igbo leaders to speak up. What are you afraid of? Second term or what? Go to President Tinubu and tell him, "Mr. President, what you are doing to our brother is wrong. Stop it." You have stopped it in other instances, in other cases. You stopped the prosecution of Iwo. You stopped the prosecution of Showore. You stopped the prosecution of the secretary or chairman of Mietiala. Why are you pushing ahead with the prosecution of Nnamdi Kanu? Simply because he's Igbo? Why are you doing that? You should stop it. They have the power. where the blame, you know, you can lay some blame on the judiciary, but in this very case, the buck stops at the president's table. The blame must be laid where it should be laid. The court cannot activate any trial without prosecution. This prosecution has hit a gridlock. It should stop. And if they have issues with Nnamdi Kanu, they should call him to the table and settle those issues. And the issues are clear anyway. He said determination, that is all. Every other thing that is coming under that is trumped up, just to make it look like a case that is fit to be settled by the Nigerian judiciary. I'm here to tell you that it is not possible. It is not possible. It has become very, very clear. If anybody keeps insisting, the courts must settle it. Think of the person that stole your election, and the moment you open your mouth, he says go to court. Why are we insisting on the courts settling this matter? Is somebody contriving something in the courts? The politicians can settle it as well. Political leaders can settle this, and the number one that should settle this is Tinubu. He should not inherit Buhari's hatred of the Igbo. He shouldn't do it. He should abhor it and make his new friends or make his own enemies. But by all means, he should not inherit an enmity brought by Buhari in 2015 against the Igbo, of which Nnamdi Kanu is the poster boy. Thank you.
From Igbo Union, so taking it on from there, you see, the war is on Nigeria now, based on the American President Trump's threats. And if you watch in the court today, we have about 2 or 3 foreigners covering this event. I want to plead with Mr. President, please, this particular trial is embarrassing Nigeria. Tell me the law upon which you are trying me. Tell me the law upon which I violated. Now, he has filed a motion, and to clear this particular doubt, Nnamdi Kanu is not running away from defense. Remember that he has already filed his witnesses, about how many of them? 23 of them, to tell you that he was ready to enter into defense. But in law, if you see something that you're supposed to raise and you do not raise it, it may be seen as you waving it. And based on that, thank God that, of course, you will know that he's intelligent. You will know that he's a good decider. So, based on the advice by his consultants, both foreign and local, and his own research, he discovered that there was not even law. Just like my colleague said. So he said, what am I entering to defense for? So that gave rise to the motion he filed. And in that motion, he raised a lot of issues. Now, my lord said, please, you people talk about extraordinary rendition. And I want somebody to come and testify and need evidence towards that. And Nnamdi Kanu said, no, you cannot need any other evidence. Where the law has mandated you to take judicial notice of every law, every judgment, every document in the court file. In that judgment in the court file, there is Court of Appeal judgment there. There is a Supreme Court judgment there. Right. There is a Federal High Court judgment there. There is Kenya Court judgment there. United Nations. All these judgments are in that court file, and the court is expected to take judicial notice of all those issues. And the Nnamdi can also file notice of preliminary objection. In that notice of preliminary objection, he also raised all these issues, and that was why Nnamdi Kanu said, my lord, during your no case submission, ruling on no case submission, you failed to take judicial notice of all these issues. So I believe that without going into what is pending in court, I believe that my lord will reconsider this particular motion, because my lord said that I have seen the motion. When the prosecution said that the one he had was not, my lord said no, the one in the court was filed, was signed, and the court belief cannot serve you on stamp and unsigned document. I don't know where they got that one. Whatever that is the case, court has confirmed that it's in the court file. I believe that my lord would have. Nobody is above mistake, of course. In fact, court is not a court of know-it-all. Court is expected to raise issues where you are confused or something that you need to clarification. You ask, please, can you address me on this issue? I expected my lord to say, this thing this guy is raising, can you people address me on it? Let us pass the hurdle. You can make your judgment in one way or the other. You are in one way or the other. I don't say so. Master Nanka said, I cannot. The Lord did not say I should enter
defense. The law said that you should do this. So that is where we are, and I believe that just like Special Counsel said, the Igbos, Nigerians of good conscience, you people should rise. Like when the issue of June 12 came up, all of us in this country stood against it and worked against Abacha. Without finding that Abiola is involved, Abiola is not involved. We collectively fought against that. Why should that of Nnamdi Kanu everybody is running away? Probably because of one or two contracts we are getting, because of the answer the president calling good person. The president just like Buhari today. Buhari died in this country and everybody was jubilating, including people of Daura. They were jubilating that Buhari died because of the bad legacy he left for himself and for his children. Mr. President, you are a Democrat, you fight for this democracy. Please, you know that Nnamdi Kanu never committed anything. They arrested him so as to stop him from agitating. Please, release him and allow him to go with the agitation and dialogue. Thank you.